What do a Beverly Hills plastic surgeon, a real estate mogul with a dozen properties, and a couple once sued by the U.S. government all have in common? Well, they didn't just survive legal attacks, they walked away with their wealth intact. So how do they do it? Let me show you how the elite stay lawsuit-proof without breaking the law, hiding assets, or losing control. I am the business guy, the CEO of the Lawyers Limited law firm and asset protection planners. And if you want to learn how to legally protect your assets from lawsuits, subscribe if you haven't. I bring you real-world strategies the rich use but rarely talk about. Let's get into it. Let's start with a true story. A prominent plastic surgeon in California, let's call him Dr. M, he had a thriving practice and over $5 million in real estate and investment accounts. So one day, he was hit with a malpractice lawsuit, not a small claim. This one had the potential to wipe him out. And here's the kicker. It was completely false. Now, Dr. M had malpractice insurance, but like many policies, it had exclusions and it didn't cover alleged fraud. And I mean alleged, which is what the lawsuit claimed. So he came to us panicking. We stepped in and we structured a Cook Islands Asset Protection Trust, but not just the trust. Here's how it worked. The Cook Islands Trust, an irrevocable trust based in a jurisdiction that doesn't recognize U.S. court judgments. Now, irrevocable with a cravat. The settlor of the trust can recommend to the trustee they make changes, add beneficiaries, take away beneficiaries. So there's ways we can make changes without losing the asset protection nature. Okay, inside we put a Cook Islands LLC. If you watch many of the videos, you see how we do this. We placed an LLC, a Cook Islands LLC inside the trust. We made Dr. M the manager of the LLC and the signatory on the Swiss bank account. So now we have control and protection. While the waters were calm, Dr. M controlled the LLC and the assets, but once the lawsuit hit, our licensed bonded trustee in the Cook Islands took over the control, protecting the assets under the foreign jurisdiction. So the result, the plaintiff's lawyer got nothing. The case eventually fell apart. I mean, it was a frivolous lawsuit anyway. Dr. M kept his money, his property, and his practice. Now, let me make this clear. We don't hide assets. We didn't break any laws. We just followed a time-tested legal structure. Now, if you're not familiar with how this works, let me walk you through it. A Cook Islands Trust is an irrevocable trust based in the Cook Islands, a country in the South Pacific with rock-solid asset protection laws. The key benefit? U.S. court judgments are not recognized there, but the real magic happens when we add the Cook Islands LLC inside the trust. So here's the structure. You, the client, are the beneficiary of the trust. The trust owns the Cook Islands LLC. You're the manager of the LLC, so you can still control your investments. You go online, do your stock trades and so on. You control your real estate, bank accounts, etc. Real estate requires other tools, land trusts, LLCs, equity stripping arrangements, which we put all that together. Our licensed bonded trustee company, law firm, only steps in when a lawsuit threatens your assets. In other words, you drive the car until you need somebody else to park it in a secure garage. That balance of control and protection is why this structure has become the gold standard for high net worth asset protection. So here's the real estate investor with 12 properties. The power of timing is a big deal here. So let me tell you about another client, a real estate developer. We'll call him Sam. He owned 12 properties. He was doing well until one of his developments went south due to zoning delays and contractor issues. Investors sued. Then lenders came knocking. Suddenly, Sam was facing multiple lawsuits. Now, thankfully, Sam didn't wait until things got ugly. 2 years later, he'd come to us and said, I've done well. I want to make sure that I keep it. Smart man. So we set up the Cook Islands Trust and LLC structure, just like we discussed. And when the lawsuit hit, the properties were already legally protected. And better yet, because the properties were equity stripped with LLCs and promissory notes, there was little for creditors to attack domestically. We got a third-party lender to go in and purchase those mortgages, those liens we put against the property, put the proceeds in his offshore trust. So it wasn't about hiding. It was about being proactive. So timing is everything. Asset protection doesn't usually work as well retroactively. You must act before the storm hits. Okay, now we're going to talk about the most controversial case in offshore trust history. This is called the landmark case, FTC versus Affordable Media LLC, or the Anderson case. No conversation about offshore asset protection would be complete without mentioning one of the most misunderstood and misquoted case in this space. Now, this case is often brought up by critics of offshore trusts. They'll say, see, the trust didn't work. The court held them in contempt. But that's like blaming the seatbelt for a crash when the driver was texting. Let me explain what really happened, and more importantly, what went wrong. Now, Michael and Denise Anderson were a married couple living in Nevada. In fact, I spoke to the Anderson family family before they passed away. They ran a business called Affordable Media, which marketed high-yield investment programs. Now, they weren't running the investment programs themselves, from my understanding. They were operated by others, as it turned out, that were part of a Ponzi scheme. But the Andersons did market them, and they profited from them, which put them in the government's crosshairs when the scheme collapsed. Now, the Federal Trade Commission accused them of participating in the deceptive practices for the people who were actually doing the dirty work, and whether the Andersons knew about the Ponzi scheme or not, the FTC pursued them aggressively, seeking to recover what it considered ill-gotten gains. Now, here's where the trust comes in. The Andersons had previously set up a Cook Islands Asset Protection Trust. We didn't set it up, by the way, intending to shield their personal assets from creditors, including, as it turned out, the federal government. But the way that the trust was drafted was, frankly, a textbook example of how not to set up an offshore trust. The mistake wasn't the use of a Cook Islands trust. In fact, the Cook Islands law worked exactly as it intended. The problem was in the drafting. Their attorney, who clearly didn't specialize in asset protection like our law firm does, made a series of rookie errors. Most notably, the Andersons were named as the protectors of their own trust. Now, what does that mean? A protector in a trust has the ability to hire and fire trustees, amend the trust in certain ways, and even influence distributions. It's a role that carries significant legal power. So by naming themselves as protectors, the Andersons effectively kept too much control over the trust, and when the U.S. court demanded they bring the assets back, they said, "We can't, the trustee controls it," and the judge didn't buy it because the guy who drafted the trust had named them the protector of the trust. Why? Because as protectors, the Andersons had the power to replace the trustee, and in the court's eyes, it meant they had indirect control over the assets, even if they weren't directly managing them. So the court held them in civil contempt, not because they had a Cook Islands trust, but because the trust had been drafted in a way that gave them too much legal influence. So it created a contradiction. On one hand, they claimed they didn't control the assets. On the other hand, the document showed they did or could. So it was a glaring structural flaw. What's important is to understand this. The failure here wasn't the concept of the offshore trust. It was in the execution, specifically the legal design of the trust. Had the Andersons used a seasoned asset protection professional, one who understood offshore trust law and how U.S. courts can analyze control, they likely wouldn't have been held in contempt at all. So when we set up Cook Islands Trust, we never make the clients the protectors. We use licensed bonded trustees who are independent and who don't take control until a lawsuit strikes. Until that time, clients control the Cook Islands LLC inside the trust. That way, there's zero ambiguity about control, and no U.S. judge can claim you're pulling the strings behind the scenes. This one misstep, naming themselves as protectors, turned what could have been a bulletproof asset protection structure into a legal liability. So let that be a lesson. It's not enough to have the right tools. You need someone who knows how to use them correctly. Fortunately, their assets were still protected. Amazingly enough, it got them in hot water, but their assets were safe. Got them in hot water for a little while, but they ended up, they kept all their money. Definitions and clarification. Let's demystify the jargon. So let's clear up a few common questions. Is a Cook Islands trust legal? And the answer is absolutely. Offshore trusts are legal when set up properly and used for legitimate purposes like lawsuit protection, estate planning, and privacy. Is it hiding assets? And the answer is no. It's about relocating legal ownership. So the assets are still declared for tax purposes, but they're protected under different jurisdictional laws. Will I lose control? And the answer is no, unless you're sued, and even then the trustee's job is to protect your wealth, and that's the point. Think of it like having an airbag. It only deploys in a crash. So let me give you a simple analogy. Imagine you live in a house that could be robbed at any time. You install locks, cameras, even a safe. But what if you knew ahead of time that someone was planning to break in? Would you leave your valuables in the house or move them to a bank vault? A Cook Islands trust is that vault. The LLC is your private safe inside that vault, and you hold the key until you need somebody else to protect it. Because if you held the key, the judge could force you to use that key to hand over the assets to your enemy at law. So that's the point where you want the licensed bonded trustee law firm that we've had a relationship with our personnel for 30 years, nothing but integrity, step in to protect you. Next, statistics. Here's why this matters more than ever. There are more than 40 million lawsuits filed annually in the U.S., and a person with $1 million or more in assets has a 1 in 4 chance of being sued in the next 12 months. 80% of high net worth lawsuits come from frivolous or exaggerated claims. So think about it. You could do everything right, follow the law, run a clean business, pay your taxes, and still lose everything in a courtroom. So it isn't about paranoia, it's about being smart. So who needs this? The right candidates and the wrong candidates. So who is a good fit for a Cook Islands trust? Business owners, physicians, real estate investors, entrepreneurs with intellectual property, high net worth individuals concerned about liability. So who's not a good fit? Well, people who are already in the middle of a divorce, because by that time there's a financial restraining order in place. Those people who are trying to evade taxes, they're not a good fit. Anybody looking for a get out of jail free card, doing something illegal, hiding illicit gains, we wouldn't take them as clients. They're not a good fit. So we only work with people who want to legally protect their legally obtained assets before trouble strikes. Okay, so what happens after the setup? This is one of the most common questions. Okay, business guy, I set up the trust, now what? So the answer is simple. You live your life. You can still manage your LLC. You live the asset protection lifestyle like I do. You can invest, spend, and control your assets through the trust. Your trustee remains in the background until or unless they're needed. And because we've done this more than any other firm worldwide, we've set up more Cook Islands Trust than any firm. Our process is smooth, legally sound, and tailored to your goals. So, okay, now let me touch on something people don't often talk about, the emotional relief. Now, when Dr. M knew his wealth was safe, when Sam saw his 12 properties secure, they didn't just protect the assets, they got the peace of mind back. I mean, I've seen clients break down in tears, and not out of fear, but out of relief. That moment when you realize you've taken your financial future out of the hands of others and into a legal structure that actually works is powerful. And that's why I do what I do. It's tremendously satisfying to see people relieved so tremendously after they've been under such stress. So let's go ahead and wrap this up with some practical advice. If you have significant assets, real estate investments, stock market portfolio, for example, a successful business, don't wait. Assess your risks. If you're a target, act now. Don't rely solely on insurance. Insurance companies are in the business of denying claims. Read the fine print. Next, plan proactively. Once you're sued or once you're divorced, it's too late. Once you're sued, there are still things we can do, but it's better to protect yourself beforehand because it'll be less costly to protect yourself and you'll have a lot more peace of mind. Next, use proven structures. Offshore trusts in jurisdictions like the Cook Islands, Nevis, Belize, combined with LLCs offer real protection. Finally, work with the right team. I mean, it's complex law. You want somebody who's done this again and again. My firm's been doing this longer than just about anybody, and we can help you do it properly. So here's the final word. If you're serious about protecting yourself and protecting your assets, protecting what you've built, you can visit us at assetprotectionplanners.com. And if you got value from this, don't forget to subscribe to the channel if you haven't already for more insights that could save your wealth, your sanity, and your legitimacy. I mean, you want to subscribe to somebody who can help you make money. You want to subscribe to somebody who can help you protect money. And I'm the CEO of the largest asset protection company in the country. So I'm the business guy, the CEO of Asset Protection Planners and the Lawyers Limited Law Firm. So stay safe, stay protected, and as always, stay ahead of the lawsuit.